I'm going to direct my discussion to you guys. First, I want to say thank you to Javier and World Jurist Association for the opportunity to moderate this panel. And I see we are comprised of esteemed experts and the titans of torts from all over the world. Today we're going to discuss access to justice for personal injury victims. The World Justice Project estimates that there are 1.5 billion people unable to obtain justice for administrative, civil, or criminal justice problems. 4.5 billion people are excluded from some opportunity that the law provides. 253 million people live in extreme conditions of injustice. Add these figures up, and it's roughly 2/3 of the world's population that is facing one of these justice issues. According to the 2019 World Justice Report, 36% of people worldwide reported have experienced at least one justiciable problem in just the last 2 years. So the concept of access to justice is about giving people a voice and an opportunity to get justice when they're injured. When we talk about access to justice for personal injuries, the meaning varies across regions and cultures. We're going to talk about access to justice for an individual in the United States. It might relate to a car accident or a faulty product, like an exploding washer dryer that causes burns, or a union worker who's injured at work, someone injured by a drunk driver, or a victim of a building collapse caused by a greedy landlord skimping on necessary repairs. We must acknowledge the tireless efforts of small law firms throughout America who come forward to represent the individuals. These firms play a pivotal role in ensuring that big corporations are held accountable. Beyond individual cases today, we will try to tackle larger issues of personal injury. We will also discuss how victims of large-scale greed find their way to justice. How do we deal with a group of people, like a cancer cluster that we just discovered in Salinas, Puerto Rico, where we identified 37 residents, all diagnosed with breast cancer, all in a very short period of time, all related to leakage from a medical equipment sterilization plant? How do we deal with the opioid crisis, with hundreds of thousands of people overdosing on opioids due to the negligence of pharmacies overselling, doctors overprescribing, and these companies lying about the addictive traits of their drugs? All of these cases can be winning cases in the United States. Outside of the U.S., we're faced with other problems. How do we deal with cases like the one we've had in Brazil, where we've had 750,000 homes destroyed, 19 people killed, when they all fell victim to a large British mining company that was negligent in maintaining a tailings dam that collapsed and resulted not only in personal injuries, but also became one of the largest environmental disasters in living history. This case had to be filed in England in order for us to help these people get access to justice after determining we could not get an equitable trial or a settlement in Brazil. We've now been litigating that case in England for the last 5 years, where we hope to have a trial next year. It's a great example of utilizing a novel path to gain access to justice. Another instance, according to the National Institute of Health, PFAS chemicals have been found in the blood of 97% of Americans. In the U.S., thanks to some of our great joint venture partners, Paul Napoli, who I was just discussing, and some others, we've been able to hold these companies accountable. But how do we deal with PFAS globally? How are we going to deal with this litigation where these toxic, deadly chemicals are polluting the world's water supply? Again, it's all about David versus Goliath. It's all about leveling the playing field so that the victims can actually get justice and companies can't do what they've been doing for hundreds of years, taking advantage of the innocent who are not represented and don't have a voice. So we are here as personal injury lawyers to give a voice and bring justice to help get recoveries for those victims, to overcome the predatory corporate power. We are here to provide access to justice for plaintiffs who require us to pursue cases via a multitude of avenues. For myself, I think my story is all about access to justice. I started out working for the United Nations for 4 years in international affairs in their Office of Legal Affairs. I then joined a personal injury firm where we represent in state courts here in New York hundreds of accident victims, trip and fall cases, and medical malpractice victims. So those cases are all handled here in the state court by a dozen or two of attorneys here. We also have a workers' compensation department and firm set up just to do workers' compensation, where most of the cases are here handled administratively with on now mostly Zoom hearings before judges, where we get those people who are injured at the workplace, we get them their compensation. We even have a no-fault firm set up specifically to handle claims by medical providers against insurance companies. And this came about because when I was handling personal injury cases, I saw there would be a sort of a residual $1,000 claim always left over as a lien from their medical providers that was not paid by the insurance companies. And I kind of said, what's this all about? Why is there always this leftover bill at the end of the case? And I realized that the insurance companies would deny those last claims, knowing that the doctors, they might fight the bigger claims, but the doctors weren't fighting the last $1,000 or so or less of claims. So I set out to have a firm that would just go out and maybe, with some more entry-level attorneys that we continue to cycle through for the last 20 years, pursue those claims that are under $1,000 on behalf of, now we have 8,000 medical providers, 120,000 claims sitting in the civil courts here in New York. So there we have a different type of practice, different types of lawyers handling those cases in the civil claims. And then, of course, we have our mass tort and class action practice and the MDLs. Whole other breed of lawyers, as you all know, you've been to all these conferences, it's a wild bunch. And the mass tort and class action lawyers are handling these cases in the federal courts. And we're doing environmental work all over. And then, of course, we have a global firm that are handling courts and cases all over the world. And you'll hear more about that from my partner, Carolyn Taylor. So different firms require different lawyers with different skill sets. And it's all necessary in order to give access to justice to all the different types of plaintiffs that are out there. So all of those examples were just what we've seen in New York. But in my journey of handling personal injury cases, all the way to engaging with class action suits, I've come to deeply appreciate the class action system. It embodies the principle that there's strength in numbers, effectively tipping the scales of justice in favor of those who might otherwise be silenced. So here in the USA, we also have the contingency fee system. That system is a great equalizer that allows plaintiffs to seek justice without upfront costs. We also have litigation funding, which allows plaintiffs in cases that we would otherwise not have the bandwidth or resources to pursue. As president of the Trial Lawyers of Puerto Rico, we're working very hard on expanding litigation funding in Puerto Rico, creating an ABS model, similar to what's currently happening in Arizona and Washington, D.C. Our hope is that by changing the rules there, we'll have litigation funders available to law firms in Puerto Rico, as well as the law firms that have moved to Puerto Rico. There's been over 91 firms that have come there in the last 3 years. And that could ultimately be a hub for providing access to justice for claimants all over the world, probably because of the choice of law provisions in those litigation funding agreements. It could have its own spike in litigation in Puerto Rico as well. But we're hoping that by having this big expansion of litigation finance, and particularly hoping that in Puerto Rico, involving them in the equity of the law firms down there, will allow law firms to have the financing they need to help provide them more access and provide more plaintiffs access to justice. So as we move forward, let's bear in mind there is a world of variance in legal systems, from the specifics of litigation funding to the dynamics of class action suits to the legal fee systems, and each system holds its own unique insights and lessons. You're going to hear today from people from different countries that will talk about the systems of justice, what types of cases they've handled, and being able to get justice and access to justice for their victims. Every system, be it American or one of our global international systems, carries its own lessons. My aspiration today is for all of us to grasp these insights, enabling us to pave more avenues to justice. To that end, we've curated an ensemble of esteemed speakers to shed light on diverse justice systems. We're first going to hear more about the system of justice here in the United States from a U.S. attorney from Washington, D.C., Denis Mitchel. Denis, and a partner at Stein, Mitchel, Beato, and Missner. Mr. Mitchel is an experienced trial lawyer who's achieved the largest verdict in a medical negligence case in Anne Arundel County, Maryland, and has held positions including president of the Trial Lawyers Association of Metro D.C. and a chair of the D.C. Bar Tort Law Section. We will hear about systems of justice and opportunities to get redress in Australia from Simon Morrison, Managing Director and CEO at the powerhouse firm in Australia, Shine Justice, and a former national president of the Australian Lawyers Alliance. We will hear from Eric Breiteneder, the founder of Breiteneder Rexton, an internationally recognized Viennese lawyer who coined the term European collective redress, who will discuss both Austrian law as well as his use of Dutch law to help get recoveries for his clients. We will then hear about systems of redress throughout Europe from Carolyn Taylor, a partner at Milberg, residing in the Netherlands and handling cases for clients throughout Europe. We will hear from Warren Collins, a partner and personal injury solicitor at Penningtons Manches Cooper in the UK, a firm with over 500 attorneys operating since the 18th century, also with offices in Spain, France, Greece, and Singapore. And then we'll have some discussion about comparing these systems from Professor Maria Jose Azar-Baud, a professor of comparative law, an international collective redress expert, and founder of the Class Actions Observatory Advocate in Paris and Buenos Aires. And then we will open up for some questions and answers. Denis, could you please get us started?
Sure. Thank you, Mark. And, thanks very much to the World Jurist Association for this invitation. You know, when I was getting ready to do this and thought about what would the World Jurists Association want to hear from a bunch of ambulance chasers for it. It causes you to think, why is what we do important? Both generally, and I think Marc covered the access to justice piece very well in terms of its importance, but also specifically, why does the rule of law, why is personal injury law important to the rule of law? And the more you think about it, the more you're forced to conclude that personal injury cases are probably the individual citizen's most direct way of promoting rule of law and enforcing rule of law. It is personal injury cases as a branch of tort law in the Anglo-American tradition that the whole body of law springs up from seeking remedies for private wrongs. It doesn't involve the state. It doesn't initiate with the state. It doesn't initiate with anything other than an individual who's been wrong and needs redress. And that redress comes in the form of compensation. And that is one of the major purposes of tort law, of this PI, of these personal injury cases. And the other major purpose of it, and the major way it assists in the rule of law, is deterring wrongdoing. I firmly believe, after having done this in the U.S. in multiple jurisdictions, that there's a major role for personal injury lawyers in deterring wrongdoing, and that it is successful in many cases in doing so, and making products safer, making places safer, making lives better. So briefly, for those attending internationally who aren't too familiar with the American system of jurisprudence on the civil side, a personal injury case begins with a complaint filed by an individual person, generally against an individual defendant or a group of defendants that have violated a rule of law, a norm, a standard of care in the professional negligence standpoint, and that violation produced injury. There's a pleading process, usually in individual cases, which is what I do. Overwhelmingly, I don't do mass torts. I'm a single event lawyer, which is a term I heard for the first time meeting with my colleagues yesterday. I'm just a lawyer. I didn't realize I was a single event lawyer. But in these cases, there's very rarely a motion to knock out the case right out of the bat. Right? You have someone who's injured. They allege negligence, they make sufficient allegations, and rarely is there a motion. These cases are usually in the various state courts, and in the U.S., the law applicable to these cases will vary significantly, both in terms of standards of proof, but more importantly, what type and the extent of damages that can be recovered. And there's tons of variation state to state. Though, throughout all of them, there's always a discovery period where to me is the great equalizer, and one of the most profound things I realized relatively early in doing these is there's I don't think any other place in our society where a regular common person who's been harmed can call a major company, can call a major state official or government official in front of them and force them to answer questions. And there's something immensely powerful about the deposition, which is the questions under oath in front of a court reporter, where the lawyer for the injured party has the right to ask any relevant question they want as to why this company, why this individual, why this state actor did what they did and to cause this injury. And it is done in public, and it is usable at trial, and it is done both to preserve evidence but also to explore and find evidence. And it is an amazing tool of equalization of access to justice that happens in these cases, and that I can't commend enough. Whoever came up with the notion that a regular old person can take the powerful, sit them down in a chair and force them to answer questions was, in my view, one of the most important tools in the legal system. After discovery, there's generally some motions practice where aspects of the case are attempted to be knocked out. The more complicated the case, the more well-financed the defendant, the more frequently and in-depth those motions are. And then following that, there's a trial. And in most personal injury cases against private entities or individuals, that is a jury trial. And against the state, it is frequently jury trial waived in many jurisdictions, and against the federal government, it is also there's also a statutory waiver of a jury trial. Or to put more precisely, the government must waive sovereign immunity, and it does so on the condition that you don't get a jury. A bit about the first purpose of this field of law, of these cases that I discussed, which is compensation. It's sort of obvious. Everybody knows you bring a personal injury case in order to obtain a monetary recovery. And why it's so important, though, and why it is such an access to justice issue requires you to consider the alternatives. You know, in many places and in many epochs of our history, if somebody harmed you, you harmed them back. And it was self-help, and it was an eye for an eye, or more so, might makes right. Whoever was more powerful could obtain justice, and whoever was less powerful could not. And so the system of monetary compensation for harms, again, an equalizer and a major point of access to justice for the common man or woman. The alternatives to that are so hard to contemplate that they don't really, you don't even occur to you. But I've said in many opening statements in personal injury cases to the jury, look, the reason you're here is because we don't have a self-help system when somebody gets hurt. The reason you're here is we don't have a system where might makes right, or where if somebody of a drunk driver runs a red light and kills a person, you don't get to go kill the drunk driver's family or the drunk driver, him or herself. You have to go to the courts and ask for redress. And it's a very important feature and a very key feature that often gets sort of taken for granted, but I think it is important. And the compensation aspect of it is essential, because every personal injury case I think of in the U.S. of as a three-legged stool. The one leg is you have to have provable wrongdoing, and the second leg is you have to have sufficient damages to justify the time and expense of the case, and then you also have to have a payor. So if any one of those legs is knocked out from the stool, the case cannot stand up, so all case analysis is looked at that way from the get-go. Are there significant damages to justify the expense? Is there real wrongdoing, and is there someone who can actually pay for this? The drunk driver cases, frequently there's not. I mean, you may have a small insurance policy, and it may just not. It's almost, you get a little bit, but not much. Frequently, you don't have someone who's there holding the bag. So, on to the second purpose of personal injury cases, or tort law more generally, is deterrence. And this is where I think the rule of the personal injury system really aids in the rule of law, right? This is private enforcement of laws and norms and standards, sort of akin to private attorneys general, is a term frequently used by courts and by statutes in this country, where the law deputizes the average citizen to enforce societal norms, enforce societal standards, if that individual is injured. And there's no doubt in my mind it prevents violations of law. It deters people from acting dangerously. It enhances individual safety. I do a fair amount of individual product liability cases, which you have to be very careful selecting, because you can get upside down on them very quickly. But I have collaborated with many of people like those sitting around me on this panel who do mass torts, and there's just absolutely no doubt in my mind that the plaintiffs' bar on mass tort law in this country and elsewhere have made drugs safer, have made cars safer. It is a major and important part of our justice system that private citizens can demand of others in the society that they will behave in a certain way, and hold them accountable when they do not, and people will adjust their conduct accordingly. And I would be remiss if I didn't end this by talking about our jury trial system, which is it sort of takes everything I've been talking about in terms of access to justice, rule of law, private enforcement of norms, and magnifies it. This is 6 or 8 or 12 randomly selected people from society being called into a courtroom to adjudicate what the norm is going to be in a given situation, how people are supposed to behave, what is the standard which we will accept as a society. And for that reason, I think it is the single most important way in which individuals can enforce the rule of law in a jury. And it never ceases to amaze me when you try your cases, and the older you get and the better you get at picking your cases, the fewer you try. But I still try a couple a year, and I'm humbled when you stand there and talk to these 6 or 12 citizens, depending on which jurisdiction I'm in, and ask them to take time out of their lives. And I'm astounded by how seriously they take the job and how much it adds to the quality of the process. So that's a little bit on the importance and the American or uniquely United States aspects of these cases.
Thank you, Dennis. Simon?
Thank you, Mark, and thank you to the World Jurist Association for this opportunity. It's a real privilege to be here. I manage a plaintiffs firm down in Australia and New Zealand of about 1,000 people. We have 2 very different systems of personal injuries law in those 2 countries. So I'm going to walk you through the evolution of the personal injury system in both Australia and New Zealand and take you to where it is in present day. Let's start with Australia. We're right down the bottom of the world. We have 25 million people. We are the home of the kangaroo. We are the home of Crocodile Dundee. Our personal injury system is a hybrid system. We can sue for common law damages and we get statutory compensation on a no-fault basis. Let's switch to New Zealand. Also right down the bottom of the world, 5 million people, home of the sheep, lots of sheep, home of the All Blacks rugby team, possibly the world's greatest sporting franchise. Personal injury system, pure no-fault compensation. So let's go back to the start. Australia and New Zealand inherited from our mother country, England, the common law system, the right to sue for damages for personal injuries. I'm going to walk you through a timeline of what happened in both our countries to let you know where we've arrived at today. So the story starts in 1932 in England, in the House of Lords, and the famous case of Donoghue and Stevenson, infamously known as the snail in the ginger beer bottle case, set the frame that allowed us to sue in negligence. 1967, New Zealand. Sir Owen Woodhouse, then a Supreme Court judge in New Zealand, designed a revolutionary compensation system for that country, which would wipe out the right to sue for damages and replace it with a pure no-fault compensation scheme. 1972, Australia. Sir Woodhouse is retained by the Australian government, having met the Australian Prime Minister on a cruise ship in 1970 and persuaded him that Australia should consider abolishing the right to sue for damages as well. He designed such a scheme for Australia, and in 1975, the Australian government presented a bill to the Parliament to wipe out the right to sue for damages. I want to take you to the most memorable day in Australian politics. It was the 11th of the 11th, 1975. It was one of the most controversial days in our country. Sir John Kerr, the Governor-General of Australia, the Queen's representative in our country, dismissed the Australian Prime Minister and his government owing to their inability to guarantee supply for the country. Fortunately for us, the bill for no-fault compensation died with it. I want to fast forward 50 years to today and tell you what you see. Australia has a hybrid structure which allows us to sue in negligence and also recover statutory compensation. In New Zealand, the right to sue for damages for negligence remains abolished. Now I want to share some pretty scary statistics with you about the two legal systems. The incident rates of serious injury for work damages, for work accidents in Australia, 10.5 claims per 1,000 employees. In New Zealand, 18 per 1,000 employees, almost double the number in Australia. The outstanding claims liability that currently sits in the New Zealand no-fault system is a staggering $56 billion. For a country of 5 million people, that's a scary number. I want to give you a comparison. Let's pretend that this system was overlaid in the United States, and on a like-for-like basis, using the same metrics, the outstanding claims liability for the US would be some $3.5 trillion, more than 10% of the current gross debt of the United States. So what's the moral to this story? Pure no-fault compensation may sound very attractive, but there is simply no substitute, philosophically and economically, for the right to sue for damages and negligence. Thank you.
Thank you, Stein. Eric?
Yeah, thank you, Mark, for the introduction, for the very interesting numbers. Thank you, Denis. You already took over like a part that I wanted to flag as well, because why does the World Jurist Organization invites us as being mainly plaintiff lawyers procuring claims for individuals or for groups like our firm is doing? I think the very important part is about access to justice granted in various situations, or especially the personal injury law can't like serve in a proper way and stop misbehaving of entrepreneurs or bigger enterprises. Think about the Roman Emperor Caligula. He walked apparently through the streets of Rome. He slapped in the faces of passengers. And behind him was a guy compensating a certain amount of money. Did it stop him from doing that? No. Think about the Fort Pinto in the 70s in the US. A very famous case, which I think, and I hope my American colleagues will help me if I cite it wrong, but as far as I recall, it was a construction issue in the car that caused a lot of major injuries and deaths of several people, because when the car crashed, the tank basically flooded into the passenger cabin and everyone was fried. So it was not reasonable for the company to change that construction. It was more reasonable to risk that more people had an accident and actually died because of this construction issue. It was simply to compensate them. So compensation in personal injury situation is a very important part without any discussions. But in some situations, it simply is not enough. And then this is the event when we come to collective redress, like we like to call it in Europe, simply because the class actions, as we see it in the US, basically asking for punitive damage, is something that is not in the mindset of Europeans when it comes to damage compensation. It's not about how much shall a company pay to stop a misbehavior or to change a construction, or like in the diesel scandal, to stop polluting in an enormous amount the environment by not following regulation or intending to misinterpret existing regulation. So we have in Europe a directive on collective redress, which is dated 2020. We have 27 member states. To my knowledge, we have 3 member states who transferred the directive already in national law, only 3 of them. And it was due in December 2022. So those countries are Lithuania, it is Hungary, interesting, very interesting for me because they're normally always very controversial when it comes to Europe, and the Netherlands. So I think the importance of these conferences is that we all have the opportunity to learn from each other which concepts different litigations offer for more or less the same problem. So for us, it was always important to, as we having not a collective redress system in Austria, but we have an opportunity and we have some flexibility to create our own system by using, for example, a Dutch foundation to bundle interests, but procuring individual claims in Austria. So it's possible, but, and coming back to the topic of this conference, it is not enough yet. I think in a situation of a mass claim, of a mass harm, there is not enough what allows individuals to have access to justice, because sometimes they really struggle with the cost risk of those tort claims. They are afraid of going in individual cases against big companies that engage an army of lawyers that trying to delay court proceedings as long as funds on the plaintiff side are simply gone. So there is still a need to provide a proper access to justice. That's what we are working on, and I also like very much the idea that Denis brought. We have a role as plaintiff lawyers, as prosecutors, to procure claims for our clients in the most reasonable and proper way. And by having still a lack of collective redress tools, we simply need to be creative. We need to learn and try to show also to the lawmakers solutions, not only complain about that they have not acted in the right way. So that's why we are also using tools from the Netherlands, we are using tools from Germany. We are working cross-border because I think it's not, it is not something you should look at it from a nationalistic or individual side. You need to look on a broader base, because our defendants are doing the same thing. They are betraying in the US as well, they are doing it in Europe. And if we can apply at least some tools we have learned in America or across the world, we hope that we can, in the end of all day, make this world a better place for not only for the victims, but, and this maybe sounds strange, also for the perpetrators. Because for the perpetrators, it would also be important that they have, at a certain stage, after they have all their defense tools used, the opportunity to get rid of a mass claim situation, paying one time, one price, a reasonable solution for everyone. Thank you.
Thank you. Caroline?
Yeah. Thank you, Mark, and thanks to the World Jurist Association for having us and showing interest in this topic and in this panel. So my name's Caroline Taylor. I'm a partner at Milberg. We work with Mark every day. I began my practice doing personal injury, class action, mass torts, so all plaintiff-based work. I moved to Europe almost 2 years ago and basically focus my practice now solely on cases and work in Europe. As Milberg's footprint grew, it just became necessary, I think, to have someone as boots on the ground. So I was lucky enough to get to make that move. So now I interact daily with our partners in London, in Munich, in Lisbon, and in Amsterdam to push different initiatives for our firm. I think it's really easy as Americans for us to look at Europe as just this monolith, that it's all the same and you know, that it's just one country. And what we've learned is that every country is so incredibly different, from cultural perspective to the laws to the ethics. And so I think diving into that and really understanding those differences is key to being able to really push the proper initiatives and the access that we would really like to do and to provide justice to the citizens of those different countries. I think, as we've all said, and it's probably pretty clear, we don't feel like, at least I don't feel like, access to justice is nearly as far as it needs to be in Europe. I think we can really easily look at that and look at the diesel scandal as a great example of that. I mean, in 2015, Volkswagen's wrongdoings came about in the US a couple of years later. Americans were compensated for that, and in Europe, they're still in most cases, or in most countries, they're still in the procedural aspect of getting through those cases, and Europeans haven't been compensated. So there's case study after case study that we could talk about to prove up that Europeans are not getting the access to justice that they need. But I'll just run through super high level, like 4 different countries in Europe, just to kind of give you an idea of how personal injuries work there and the different issues that are facing them. So Spain does have an injury-based system. It's outlined in their Spanish civil code. You can combine personal injuries into class cases in Spain. It would all be opt-in, but the injuries would have to be very, very similar. Just like in most jurisdictions, you have to be able to show causation, usually done with an expert report. And you can get economic and non-economic harm, so what we would consider to be, you know, medical bills, lost wages, things like that, but also what we would call in the US pain and suffering, or I think in Spain they consider it moral damages. However, they go by a table. So there is a compensation guideline for different injuries in Spain that the judges will look at, as opposed to really diving into the individual circumstances. Also, from a financing standpoint, Spain's a little bit different because they do allow for contingency fees. So that does provide a little bit more access to justice than some of the other civil code jurisdictions in Europe that do not allow contingency fees. But in practice, what it seems like is that typically the cases that are taken on contingency are repeat cases. So maybe it's a product defect and there's already been a case that the liability has been proven. Then Spanish lawyers will take that a little bit more on contingency because it's a more well-known outcome as to how that case is going to go. Staying on the Iberian Peninsula, if we look at Portugal, same thing. They do have personal injury cases. There is no third-party funding for these cases, so they're either going to be, and there's no contingency fee. So either your client's having to pay or there's going to be insurance, which is obviously difficult for a client to do at some times. Damages, they are not considered to fully compensate. A death case in Portugal is worth about $50,000 to $100,000. So again, just not fully compensated for the injuries that people suffer. Germany, they do, again, have personal injuries. They are financed by either insurances or private pay from clients. The damages there can be reduced for contributory negligence. Again, you can get economic and non-economic damages, but for the pain and suffering section, judges again look to a collection of judgments and kind of have a range of what they can compensate. So again, it's kind of in a box for different injuries. Last up is Netherlands. Eric's been talking about a little bit already. So most cases in the Netherlands that are personal injury based are settled, I'd say probably 90% before they go to court. So the odds of us actually litigating a case in the Netherlands are probably about the same as me having a hippopotamus in my hotel room. But they do happen, just very, very rarely. The same thing in the Netherlands. They have basically a structure and a guide as to how damages have to be paid out from a pain and suffering standpoint. So just comparing those 4, you can already see some similarities. with the exception of Spain, you're already going to have either your client paying or insurance, which is very often a barrier for access to justice. Also, most of these countries have these guidelines, and so maybe a lost arm is worth X amount, and it doesn't take into consideration your individual circumstances. So, for instance, me losing a finger is a lot different than a concert pianist losing a finger, and these different jurisdictions, they just don't account for that. We do see personal injuries in just a little bit other realm as well. I know Marc was talking about PFAS, so there are just financial damages related to PFAS, whether it be we represent some fishermen who can't sell their fish anymore because there's too much PFAS, or water companies who are needing to remediate. But there are also personal injuries related to PFAS. But all the people that have been exposed, there are all kinds of health risks that go along with that depending on the level of exposure. So we're really keeping an eye to see how those develop. So I think overall, I agree with everybody on here that these cases are still difficult and time-consuming, and they don't really fully compensate people. But I'm excited to see how the EU and the other jurisdictions to continue to develop to try to push these initiatives and give people more access.
Fantastic. Thank you, Colin. Warren?
Thank you, Marc, and thank you to the World Jurist Association for inviting me and for me to talk a little bit about personal injuries litigation in England and Wales. So first of all, I'm going to start with a geography lesson before we get into the law lesson. UK. UK is made up of 4 countries. 3 of those countries are on the island of Great Britain, and that is England, Wales, and Scotland. England and Wales is one legal jurisdiction, Scotland is a separate jurisdiction, and then there's the third jurisdiction, which is Northern Ireland, which is on the island of Ireland. So England and Wales, but most of what I'm going to talk about England and Wales also applies to the other countries within UK. We're a common law jurisdiction, and personal injury is usually based on the law of negligence. It's supplemented with some but limited statutory provisions. And occasionally in personal injury cases we rely on the law of contract. A little about the legal profession. This will confuse a lot of folk. We have a split legal profession. We have solicitors who tend to do all of the work on a personal injuries case up to trial. Then we have the trial lawyer themselves. That's the barrister. They do the advocacy at trial. But I put that against the background that about 98% of all personal injury cases that are filed in court settle. We have very few trials. And then we have a hybrid like myself, and we are solicitor advocates. So solicitor advocates are more like an American attorney in as much as we handle the case from cradle to grave. We can take the case right up to trial. But quite often, solicitors or solicitor advocates will work with barristers as much as part of a legal team, so that there's some strategic decisions can be made along the way, in the same way that more than one attorney may partner up in a case. So I mentioned that we're a common law jurisdiction. We work on the law of negligence. That consists of 3 elements. First of all, establishing a duty of care, then a breach of that duty, and then finally the consequential loss, which in personal injury cases will be the injury itself and the consequential financial losses. In the English jurisdiction, the burden of proof rests with the plaintiff or the claimant, and that's to prove negligence on the balance of probabilities, more likely than not that there has been some negligence, which is different from the criminal burden of proof, standard of proof. So I thought I'd give you some key features in the English jurisdiction. And one of the most distinguishing features is, even though the English jurisdiction invented it, we've abandoned trial by jury. And personal injury cases are tried by judge alone, whether or not it's a claim against an individual, a corporation, or an emanation of the state. It's always a judge alone. The second feature is we have no punitive damages. Damages are purely designed to compensate the accident victim and not to punish the tortfeasor. We do, however, have unlimited motor vehicle insurance. Every driver of every vehicle, motorcycle or car or truck, will have unlimited insurance, which means that we're not challenged by policy limits on cases. There are the occasional motorist that breaks the law and doesn't take out motor insurance. We have a safety net for that. We have a state-run organization which all motor insurers have to pay into, and that's called the Motor Insurers Bureau. And they will pick up the tab for claims against uninsured motorists or untraced motorists. So that's a good feature of the English jurisdiction. But we have very modest, or relatively very modest, levels of non-economic losses. And to give you an example, the general damages for pain and suffering for a traumatic brain-injured accident victim is going to be a maximum of somewhere in the order of $400,000 US. And that may sound a lot of money to a lot of people, but when you break that down into it's to represent pain and suffering for an individual that may have limited mobility, very restricted cognitive deficits, may be dependent on someone else for all activities of daily living, for nursing care. And when you break that down onto a daily rate for a young 20-year-old that's been knocked off a motorcycle that's got permanent traumatic brain injury, that is going to be in the order of about $20 a day. And in my view, that is a statistic worth reflecting on when thinking about the value of compensatory awards for non-economic losses. Another feature of English legal claims is the system of fees and costs. And the general rule is that the loser pays the winner's fees and costs. Now that can expose a claimant to a potential costs and fees liability to the defense in certain circumstances. So what's arisen as a result of that is a rather complex system of after the event insurance, legal fees insurance. So effectively what happens is that after the accident has taken place and the plaintiff or claimant goes and sees an attorney, they say, in order to run this case, you're going to need to cover yourself against your potential exposure for legal fees and costs. And an insurance market has developed where that kind of policy is available. The premiums are deferred until the end of the case, and the premiums are payable out of the claimant's damages if they succeed, and they're written off if the claimant does not prevail. And the insurance industry have worked out that attorneys would not take cases on if they thought they weren't going to succeed with them. So that's their kind of check and balance, and overall the insurance industry is making more than it's losing on that kind of product. So most cases in England are funded by way of what I call a modified contingency fee arrangement, which we call conditional fee agreement. It's a no-win, no-fee agreement, and there can be a provision for a success fee to be paid to the claimant's lawyer if the case is successful, and that is capped at 25% of the award for general damages for the pain and suffering and the past financial losses. But the future, the claimant gets 100% of, keeps everything. So the concept of damages in English jurisdiction is to put the plaintiff or claimant in the same financial position they would have been had the accident not occurred. And then there's that very small compensatory element for the injury. So when a plaintiff is injured, a claimant is injured, they're going to receive three types of damages. They're going to receive the general damages, the non-economic losses I've already described, and they are fixed by reference to a blend of some guidelines, not quite as strict as the Spanish system, but there's a range that judges will be aware of in terms of different types of injuries and what can be awarded for different different injuries. Plus, there will be there's a system of looking at precedent as to what's been awarded in the past for similar claimants with similar injuries. And that will then be indexed up to today's rate. Then there'll be the claim for the past financial losses, what's actually been incurred. And then the future losses, these are calculated by reference to the annual cost and then how long those annual costs are going to sustain, whether it's for life or for a shorter period of time. And the expert evidence will determine and assist the court with that. Once the damages have been calculated, the court, or by negotiation, the parties can agree that that can either be paid by way of a lump sum or by way of annual payments for the rest of the plaintiff's life. And that's particularly helpful where life expectancy is either in dispute or is unknown, and it means that the plaintiff doesn't run out of damages. If the plaintiff lives longer than the experts anticipate, then that's a windfall for the plaintiff. But if the plaintiff is unable to or doesn't live as long as is expected, then the defense will make money on that. Quite often there'll be a blend in a settlement of the two. There'll be a partly by way of lump sum, and then they'll say, well, some of the damages can be paid annually. Another feature of England that many of you will be aware of is that we have a free state healthcare system. Healthcare is free at the point of delivery for everyone. It's not means tested. Everyone is entitled to completely free healthcare. The National Health Service was established in the United Kingdom in 1947, just after the Second World War. The following year, immediately after that, came along the Law Reform Personal Injuries Act of 1948. And essentially what that act says is that if you are an injured plaintiff and you are entitled to state health care, you do not have to give credit for that in relation to your claim. You can claim the cost of private medical treatment. Essentially, why should the government have to pay for the tortfeasor's wrongdoing? And that often happens. And then finally, I just want to talk about some emerging trends in English jurisdiction. Like many jurisdictions, we've been facing a significant wave of various tort reforms over the last 20 years or so. And I'll give you a few examples. Firstly, we had a number of claims over the years for in motor vehicle accidents where drivers and passengers had sustained whiplash, soft tissue injuries to the neck and back, normally as a result of being in a car and then hit from behind. And those have now been taken completely out of the civil justice system. There is no concept of a claim for a whiplash-only injury. If you've got that type of injury, there is no damages at all. The insurance industry were campaigning for that for a number of years, of saying there was a lot of fraud, there was a lot of people making claims for injuries which didn't exist, and the government ceded to their campaign. The promise is that this was causing the motor insurance industry so much money that the promise was, well, we'll see motor insurance premiums rapidly drop once whiplash is outside the legal process. Not so. Insurance premiums have continued to go up. We used to have the ability to rely upon criminal breaches of statute to support claims for personal injuries. So, for example, if there'd been a criminal breach of health and safety regulations in a factory or in the workplace, a plaintiff could rely on those breaches to say, well, that must indicate there's been some negligence. And as a result of tort reform campaigns, we had the passing of the Enterprise Act some years ago, and now, just because there's been a breach of a criminal obligation in relation to health and safety, a plaintiff is unable to rely upon that. They still have to prove common law negligence. We had a number of cases where the courts were finding that sometimes plaintiffs were gilding the lily, they were exaggerating their claims and were saying that they were more harmed than the evidence would seem to support. And that led to the development of the concept in English law of fundamental dishonesty. And what that means is that a plaintiff who can be very seriously injured in an accident, and there can be no doubt about the extent of those injuries, if there is any element of exaggeration by the plaintiff and the court finds that there's been exaggeration, then three things happen. Number one, the entirety of the plaintiff's claim is wiped out, not just the exaggeration. Number two, the claimant or plaintiff will then have to pay all of the defense costs and fees, and the insurance that they would have taken out for that will not cover them, because that's excluded in all of the after-the-event insurance policies. And number three, the plaintiff will go to jail. So that has led to plaintiffs sometimes being ultra cautious about explaining the extent of their injuries, because they don't want to in any way be accused of exaggerating. And we all know that sometimes people, their memories are not 100% perfect, and they may say one thing, and then a clever defense attorney will find one slight inconsistency within the medical notes and records, and then suggest to the court that that is fundamental dishonesty. And it now seems to be almost a default practice in the personal injury cases I see, that almost in every case there's a suggestion that the plaintiff has been fundamentally dishonest. And that normally comes alongside negotiations for settlement. So it's almost like a threat that's being made. Finally, we used to have a system that if the plaintiff prevailed, the plaintiff would recover their reasonable fees and costs. Not so anymore. Now we have a system that if a case is filed in court, the first thing that the court will do at an early stage is to budget the case, and it will set a limit on the amount of fees and costs that the plaintiff can spend. And if the plaintiff exceeds that budget, even though it may be entirely reasonable, so things happen in a case where you suddenly decide, I'm going to need an extra expert, I'm going to need to go and speak to some extra witnesses. If that's not been budgeted and you go over that budget, that's the plaintiff's downfall. They will not recover the costs. So we're having a situation where either plaintiffs are having to pay the unrecovered costs out of their damages, or their access to justice is being restricted because an attorney is going to say, we simply can't proceed with this investigation of evidence because the court hasn't allowed us to do so. And that's often a battle. And then finally, I thought I would just talk about some emerging trends, and just picking up on what Caroline was explaining about the mass tort market. We have had some degree of introduction to mass torts in recent years, particularly with diesel litigation, but some products as well and some pharmaceuticals. But we have a very undeveloped procedural system to properly manage and handle mass tort litigation, collective redress. I'm beginning to see the cracks appear in that dam. I'm beginning to see a lot of interest in this area of law. And I think the final comment I would make is watch this space, because I think probably in the next 2 to 3 years, we're going to see a sudden opening up of the mass tort market in England and Wales. Thank you very much.
Thank you. Where?
Thank you very much. I'd like to thank the World Jurists Association, the World Law Foundation, and the team of the World Law Congress for the organization, but especially Marc Grossman for his will to have me in this panel with great panelists. I was very excited to be invited to this panel, which is named World Law Forum, to discuss a topic, class action on personal injuries, which is indeed about world lawyering, when the damage has been caused in a worldwide basis, and the prejudices are homogeneous and massive. I think it's fair to say that today there is a sort of new world state of play on the matter, since there are new players within the originators. I'm thinking of Australia. And if for decades it's been Canada mirroring the practice of the US, today there is a domino effect, and the practice, the US practice, impacts widely the different member states in the European Union and beyond. As a comparative lawyer and professor, I would say there is today a world's collective redress puzzle which has been under construction for ages, and it's been filled in an accelerated way today. There are different forms of class, collective, group actions in more than 40 countries, according to the studies that I brought in the Observatory of Class Actions. So this means that class actions proliferate, and this is true despite the different traditions within the European, Asian, African, and American continents. In Europe, there is an increasing demand for fairer protection. However, procedural law belongs to the legal domain of member states, so we can have, as it's been said, 27 different collective redress regimes within the European Union, and this heterogeneity is problematic, since not all Europeans will be awarded the same level of protection aside from efficiency considerations. And this heterogeneity makes hectic any attempt to describe a European-style model of class actions as a unit. Therefore, I propose to address the ongoing trends, the national ongoing trends in the European regimes, to find out whether collective redress as it stands today constitutes a suitable manner to address defective health product causing personal injuries, and to end up with considerations regarding the role of the European Union throughout the representative actions directive that has been mentioned already, adopted in November 2020. And to describe the features of the collective redress mechanisms in Europe, we can start by the name to discover that we can find everything but class actions. So the exceptionalism of the European systems is up to speed. Labels range from collective, group, popular actions, recours collectif, collective redress, collective actions. Regarding remedies, whilst every member state has had injunctions, collective injunctions, since 2009, 9 member states in 2020 still did not have a compensatory mechanism. That is why the European Union intervention was needed. Furthermore, some member states only allow to claim material damages throughout collective redress, and very little of them allow to claim through the collective mechanism for moral damages. And the key question, to me at least, is the scope of collective redress to answer to the question whether they are suitable or not to address personal injuries. Indeed, most of the time in European countries, the scope of collective redress is sectoral and confined to consumer law or other specific matters. That is the case in France, Belgium, Luxembourg, Poland, and Spain, and only minorities such as the Netherlands, Portugal, and the UK in one of the collective redress systems follow a true horizontal, or what we could call transubstantive approach. There, from a comparative perspective, personal injuries do not always fit within the class actions rules on scope. This means that victims from countries wherein class actions are largely embraced can find in the class action a suitable and efficient way to get access to justice. But if victims belong to countries whose rule and scope are very restrictive, then they will have to have recourse to individual remedies, such as individual tort lawsuits or product liability, and taking into account the hurdles that this entail, it's safe to say that many of those will remain uncompensated. A broad scope rule has at least 2 consequences that can be encountered in the matter that interests us. I would refer to health-related product and to fundamental rights. In cases involving defective healthcare products, such as breast implants, medicines, that affect or are likely to affect personal rights, and from mass perspective, they are, on top of that, transboundary in nature, as the products are distributed in many countries. Let's think of the breast implant case, PIP, the medical gel that should have been compliant but was replaced by a cheaper one. It broke. Women all over the world, they are estimated to be 400,000 women, had to have it replaced, 30,000 of them in France, where I live. There are 6 proceedings pending in France. One of those ended up by compensation throughout civil proceedings, 7,000 to 13,000 euros for the 7,000 victims who went into the criminal proceedings where the prosecutor engaged the proceedings on aggravated deception. They were constituted as partie civile. There was another case whereby 20,000 women were awarded 3,000 euros, let's say only, totalizing 60 million. They totalized 20,000 women, and this is has a sad end because the defendants were declared insolvent. In those cases, in France, victims can still turn to public funds, such as the Commission d'indemnisation des victimes d'indemnisation. And there are several other cases that are pending. The same applies to the medical device distributed by Bayer, a permanent contraceptive implant, which was withdrawn from the market. And in the United States, there was a settlement of $1.6 billion, whilst in Europe, we're still struggling to get the associations having considered as having standing to sue, so not even certified. And there are many other collective cases, but which are being treated throughout platforms whereby victims would give a power of attorney to the same lawyer. And the second case, which seems important to highlight, relates to fundamental rights. In Canada, collective redress, collective actions are an important social tool, namely to tackle abuses, pedophilia, sexual abuses, or rights of indigenous peoples. In Argentina and several Latin American countries, structural public interest litigation has grown up exponentially in the recent decades, and it's a very new field in Europe. Aside from some climate change litigation, the field is pretty unknown. So everything to get done. And through such litigation in the Latin American countries, individuals and NGOs will discuss and seek a lasting change of the status quo that undermines the effectiveness of social, cultural, and economic rights. I'm thinking of the first wave of collective actions which related to habeas corpus from a collective point of view, prisoners, denouncing overcrowding prisons, long duration of pretrial detention, and in the last 10 years, environmental, social, and government class actions, such as the ones that were discussed in the environmental panel this morning. And regarding another topic, after the scope rule, it is standing. In Europe, there's a clear tendency to grant standing only to NGOs. That is the reason why we talk about qualified entities. In general, these are consumer associations, ombudsmen, and unions, which have been acknowledged as representative upon criteria such as years of existence, public activity, independency. A few member states, like the United Kingdom in the competition collective action, Portugal and Luxembourg, allow standing to sue also to individuals, but the majority of the member states reserve them to NGOs. Another discrepancy in Europe relates to who can be represented through collective actions. In general, those are consumers, that is, natural persons, and in some cases, such as the environmental group actions in France, for instance, moral persons can be represented as well. And of course, the core question is the opt-in or the opt-out system. The very large majority of the European member states have adopted opt-in systems, aside from some countries such as the UK in 2 out of 3 mechanisms, the Netherlands and Portugal. Some member states might follow an opt-out system in the aftermath of the transposition. I'm thinking of Spain. That still remains to be confirmed. And 2 members have mixed systems. That is to say that the judge will decide whether opt-in or opt-out, and that is the case, for instance, in Belgium, that reserves opt-in for health-related collective actions, that is, personal injuries would be treated therein. And last, regarding the structure of the proceedings, systems like the Dutch one would follow, let's say, a sort of American certification period, whereas the majority of the other member states have different sort of proceedings. I'm thinking of France, wherein we have a collective group actions that follow a 3-stage proceedings, the first one being the admissibility and the merits. Then there is the publicity and opt-in. That is to say that we have a very late opt-in, and that is very helpful in personal injuries because we have a sort of declaratory decision in the aftermath of which the victims would declare in the proceedings, prove the extent of their damages, and then be compensated in the 3rd stage, which is a spontaneous enforcement or judicial enforcement if needed. In this panorama, the intervention of the European Union was needed because of the wide discrepancy in the approaches, and the directive was adopted, as said before, in November 2020. It is the result of decades of lobbying and discussions. It is a solution of compromise. The directive's name, because it's always important to see the labeling, is representative actions for the protection of the collective interest of consumers. And when we say representative actions, that means that this tool is reserved exclusively to qualified entities who represent the groups upon certain criteria. And also, the name reveals the second limit, which is prejudicial to personal injuries, which is for the protection of the collective interest of consumers. Despite the fact that only consumers will be able to use this representative action mechanism, the Annex 1 of the directive is pretty large. We have 60 European texts that are listed, so that the consumer law concept in this directive is very large and encompasses data protection, investors, tourism, trips in general. One might say that the European consumer law is enlarging widely with this type of directive that also distinguishes between domestic representative actions and cross-border representative actions, which is an important matter in a continent such as the European Union. Dramatically, the directive leaves the choice of the opt-in and the opt-out, prohibiting opt-in for injunctions and for people who do not reside in the state where the proceedings are brought. As a whole, there is an unusual number of soft law provisions, which makes us think that it will be transposed in divergent ways. So how the state of play will change still remains to be seen. In a nutshell, the greatest contribution of the directive seemed to be twofold. On the one hand, to ensure that one compensatory representative action will be available in each member state. Secondly, that there are heavy safeguards. Still, we need to be seen. It remains to be seen what the material of these safeguards will be, and there is no clear development at all when it comes to personal injuries as such. Therefore, the matter will continue to be developed through individual litigation in France. The internet platforms are a success story, but they still are individual cases to plead. Let's recall that the purpose of the representative actions was to grant collective redress mechanisms whilst preventing from abuses. It seems that the latter objective has prevailed, and that is why, with the dear friend and colleague that some of you know, we have written a paper that was where we refer to the directive as a sheep in a wolf clothing, and I think this perfectly applies to personal injuries, which are, with competition law, a field which is completely left aside. Thank you very much.
Thank you so much. Denis, in your presentation, you highlighted the jury trial process as a way for citizens to participate in the rule of law. How do you see the jury trial process dynamic evolving, particularly in an era where we have alternative dispute resolution like arbitration and mediation becoming more prevalent?
I think in the U.S., given the constitutional right to a jury, not only in criminal cases but also civil cases, I don't see the jury trial going away. I'm trying to think what would be the avenue to do that. You couldn't do that legislatively because the Constitution would not allow it, and most state constitutions don't allow it. So I think you'd have to do it with, if all insurance companies, in auto insurance, for example, if all auto insurers required arbitration, but you don't have privity of contract between the victim of the tort and the liability insurer who's on the hook for the damages, so you couldn't have an arbitration agreement between them. I don't see, in light of the constitutional nature of the jury trial right, how that would be easy to do. I'm sure our well-funded institutional opponents would like to see it happen, but I'm pretty confident that it'll be there to stay. I also think that jury trial has always had some strong support, obviously in the Democratic side of the political divide, but also there's a fair amount of support for it on the Republican side of the political divide, and that's due to the sort of sacrosanct nature of it in our system. So the long answer that I don't think in a fault-based system with the constitutional right to the jury that it's going.
I have so many more questions for you, but I think I'll save them for next year. I'd love to ask you and Jeff Quirk here, one of the finest trial attorneys we have in New York, questions more about compensation guidelines and the risk of loser pays, and some of the impacts of those what they would have here in New York, or how fortunate we'd be to have no policy limits like they have in the UK. But we'll move on and take that up next year. Simon, could you tell us, does Australia also have loser pays, and do they have ATE insurance, which we described?
Mark, we do have loser pay. It's modelled on the UK system. There are two levels of costs that the loser has to pay in Australia. The first is what we call standard costs, and they're the routine costs ordered by the court. Unfortunately, that's only about 60% of the total costs, so that the plaintiff has to wear the balance. If the defendant has been particularly naughty in the way that it's defended the litigation, the court can order what's called indemnity costs, which takes the bar up to about 90% of the bills. So either way, the plaintiff still pays about 10% on the best outcome. ATE insurance is available in Australia. It's used in class action litigation, not in individual lawsuits. It can be recovered from the pot, so the group members each contribute to the cost of the premium. Premium's pretty cheap. We pay about $200,000 for 10 million of cover. If we lose the case, the premium, if we lose the case, I beg your pardon, if we win the case, the premium steps up to about $2 million, and then it's shared across the group members.
That is fascinating. Okay, we're going to run out of time, so I will hold our questions and just say a few brief words. As we conclude this profound and enlightening discussion, I'd like to express my gratitude to our esteemed panelists for sharing your unique perspectives We've learned that access to justice in personal injury litigation, regardless of jurisdiction, is far from settled. It's far from a settled issue and demands our sustained attention, our creativity, and our collaboration. We've heard about the vast array of challenges victims face across borders, from environmental contamination to defective products, and the essential role of dedicated legal professionals like yourselves in leveling the playing field against powerful entities. We must not shy away from recognizing the shortcomings of our current justice systems and continue to speak like this and have conferences like this to discuss how we can help in our own jurisdictions. Despite persistent endeavors, justice remains out of reach for many. As I gave you the statistics earlier, many vulnerable individuals and communities are not getting served. And we need to play our part in trying to fix that. There's systemic issues and disparities in access to justice, and I encourage us to have our urgent attention and rectification of those issues. Our conversations today, let them not be an end, but rather a beginning, as they serve as a call to action, urging us to innovate, cooperate, and strive to ensure that access to justice isn't just a lofty ideal, but a reality for all, regardless of where they are or who they are. In the face of the ever-evolving complexity of personal injury law, let's commit ourselves to learning, adapting, and advocating for those who need our help the most. Thank you all for participating in this panel, for your commitment to justice, and your efforts to bridge the gaps in our global justice system. Let's continue these important conversations and work together for a more equitable and fair world for everyone. Thank you.
Thank you very much.